Clock to strike 9 o'clock by Verizon, so we're good to
A
go.
little early. Hey, wait.
Yeah, we never want to start too early. That leads to bad things. So with that, I'll call to order the Town Lock Statue Groves code enforcement hearing. My name is Amity Barnard. I'm the special magistrate for today's hearing. First thing I'm going to do is swear anybody in who's here to speak on any agenda, any agenda item on today's agenda. So if you're here for a code enforcement matter, including town staff, if you could stand if you're able and raise your right hands for me. I'll swear you all in at the same time. You can stay seated, ma'am, if it's easier to stay seated. Thank you. Do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You can be seated. A little bit about process. I think all of the items on today's agenda are either violation hearings or status/fine assessment hearings. So the order of process will be the same. When you hear your case called, the town staff is sitting at the table in front of me. You'll go to the podium that's over there to the right with the microphone. The town will put on its case first. They will show me their evidentiary case file. They will call any witnesses that they intend to call. Once they're finished with their presentation, you will get an opportunity to do the same. You'll be able to look at the case file that they want to enter into the record, cross-examine any witnesses that they've called, and present any verbal or document evidence that you'd like me to consider for this morning's hearing. So after both sides are finished, I'll make a final ruling based on the evidence that's presented, and I'll issue an order that reflects that ruling, which you'll get in the mail after the hearing. So with that, I'll turn it to the town to call its first case.
Thank you. Before we start, we have some additions and some changes to the agenda. The first item is number 1 under violation hearings, new business that has been complied. So we're taking it off of this agenda.
Okay.
Number 2, McTeed, same thing, complied. We're taking off the agenda.
Okay.
And number 6, we're moving that to another date. So we'll send notice out again. So you don't have to go through the service. We'll just take it off and.
So you're pulling that one? Okay,
Mhm.
great. Thank you.
And then we'd like to, as far as the notice of status and fine assessment, number 2, Seifert, Margaret, and Kenneth, we'd like to move that to the first position since they're here.
That's fine. And you don't, formally, we don't need to move the order or anything. You can just call them in the order that you want. That's fine. I'm fine with that.
Okay, great. So we'll call the first item, which is Seifert, Margaret, and Kenneth, 3255 E Road, 2302001, PCN number 4141431701434030, violations sections 30-43, 30-44, 30-45, 30-49A in regards to manure violations. We'll turn this over to the town attorney.
Madam Magistrate, Jeff Kurtz, town attorney on behalf of the town. This is an older case. It goes back to 2023. There was a determination on your part that there was a violation relating to the placement of manure on the property, and you had imposed a potential fine of up to $5,000 per violation. The case was subsequently appealed, and the appeal was ruled in favor of the town. The violation has been cured. The time frame for our determination that it was in compliance was only in the past month because they had not called us back to the site. Mr. Gaffigan is here on behalf of the Seiferts, and we have agreed, subject to your honor's confirmation, to a fine of $5,000 and the imposition of the $234.01, I think it is, administrative fee. And if your honor is amenable to entering that order, the Seiferts are amenable to paying that in short order, and everybody will move forward.
So do you have then, is there an agreed order prepared?
There's not an agreed order prepared, but we were just hoping. We've got a stipulation. Mr. Gaffigan can confirm we finalized this arrangement Friday afternoon, I think it was.
Yes, we didn't have time to do an agreed order, but we've, my clients have agreed with the town to,
Please.
I'm sorry. Oh, James Gavigan.
Thank you, sir.
Schultz and Bowen on behalf of the Seafords. So yes, I've spoken with the town attorney, and my clients are agreeable to the proposed resolution of $5,000 fine. The violation has been cured, and then the administrative costs. So we're agreeable to that, and we'd be willing to pay it right away and move forward.
Okay. I guess let me just ask a question as it relates to two things. One, service for today's hearing. So how is service effectuated for today's hearing? That needs to be put on the record.
Yes, Deanna Thomas, code officer for the town of Loxahatchee Groves. We do have an affidavit of service. Certified mail was sent to the respondents. In addition, the property was posted. The property, the notice was also posted at Town Hall. And that began on 8/21/2025. And they do know about it because they are here today along with their attorney.
And so what did you post? Just a notice of hearing? I remember this case, but very, very vaguely.
Yes,
So
yes.
I think it was a long time ago. So you did a new notice of hearing, is that
Yes,
right?
it's notice of
Yes.
violation of the hearing.
Okay. And then just to ensure that I have jurisdiction as it relates to any appeal that was filed, do you have that paperwork here? What did the 15th Circuit do?
They affirmed your ruling.
Okay, so can I see a copy of the order, my prior order? I guess what does the town intend to enter today into the record? It seems like it's agreed, so I don't expect it'll be contentious. If you don't want to enter your entire file, that's fine, but I certainly need to see the prior.
I
order.
have the order from 2023, the initial order. Is that what you're referring to?
Yeah, and they
should
probably
mine-
have it in their
mine's
file.
highlighted.
I might have a copy on the desk.
Okay. You wanna grab it? Oh, let's do Steve. No, it's- Special manager, thank you for your patience. Our code officer is running late. so
No,
I'm
that's fine.
over
Take
here.
your time. It's Monday morning.
Good.
My approach.
Yes, sir. Thank you. Thank you. And Ms. Thomas, when you get a second, if I could see the notice documents. Actually, show them to Mr. Gavigan first.
Yeah, again, we have no objection. We're here today, so we.
Let me ask
received
you to
notice.
switcheroo and show that to Mr. Gavigan too. I presume he's aware of it, but just let's make sure that that's the same one he's got there. Thank you.
Looks almost filtered.
Looks like the same one.
Thank you. You guys are trying to make me remember back to February of 2023. That's going way back. All right. All right, and no fine assessment order was issued in this case, correct?
Correct.
Okay. All right, Mr. Gavigan, no objection to either the order or the service documents for today's hearing. Is
No,
that correct?
that's
Okay.
correct.
And then in terms of the order, do the parties want this order to reflect any specific date, or is it just to be phrased as a one-time violation?
I would, well, I would have phrased as a one-time violation because it was an irreversible fine under Florida statutes of $5,000 per violation, and it has been cured. So it's a $5,000 fine with administrative costs associated with
Okay.
it. So that's,
The town does not have any evidence of subsequent violations, but they do acknowledge the original violation and the $5,000 fine. It's not a per day fine, it is a one-time violation for this one.
Okay, and what is the date of compliance that the parties are using?
The date of compliance, where we did the inspection, I believe it's in the last 3 weeks.
and we don't, our position is it was cured much earlier, but for purposes of this settlement, it doesn't matter. But I just say for the record that they can say that that's when they came to the property and confirmed it was cured, but we would represent on the record that it was cured before.
Yeah, typically, and I think this one, given the way that this order is structured, they actually gave time to comply. So that's why I was asking what the actual date of the violation. My preference would be to have that specified in the order so that it's very clear what it is. But if that can't be done, I'll agree to write in a compliance date just so that there's an understanding between the parties and between myself that I'm not going to see any cases going back before that date, that this matter is resolved as of that date. That's my concern. So that compliance date, are we able to lock in that exact date?
I don't think we can lock it.
Is it as of today? Is that or
Definitely
yesterday?
as of today,
Are the
Yeah, I mean, we can have it. We can pick a day. You can pick as long.
Last week.
Yeah,
Pick Friday.
that's fine. We can do.
Because we normally go out before the hearing, so.
We could just confirm that, yeah, Friday, that it's and that this, so long as this order will resolve this case and we can have the lien removed from the property.
All right, so Friday is September 5th. And the town, I would hope, would do an affidavit of compliance to
Yes.
put in the case file that matches the date that's going to be in the order that I issue. All right, anything further from either of the parties?
Just want to correct, the administrative fees are 234.05, not 01.
And that's for the February 6th hearing, is that
Mhm,
correct?
Correct.
That's fine. We'll look.
February 6th of 2023, because they were reserved in this order, so that's correct, okay. And Mr. Gavigan, you're okay with that 234.05 correction?
Yes.
Okay. So I guess, given there's agreement, but there's no agreed order, Do-
You can enter an order.
I'll just phrase it if it's mutually agreed by the parties here at today's hearing. Are the parties in agreement with that?
Yes.
Okay. So it'll be an order assessing fine, and imposing a one-time fine in the amount of $5,000 for the previously found violation, and then I'll establish a compliance date of 9/5. And I'll award the town its administrative costs for the February 6, 2023 hearing in the amount of 234.05. Anything else that either of the parties would wish to be in the order?
We want to.
No, we're gonna pay it. So is it possible for us to pay it today, even if the
Yeah.
order's not entered? So we'll go ahead, because my client's here. They'll write the check for that amount.
I'll leave that's between you and the town. I usually don't get involved in that side of things, but that if they're fine with that, that's fine. Fine for me. Okay. Anything further from either of the parties?
No.
All right. And then I guess I'll ask the town attorney. And I guess let me ask Mr. Gavigan on the record. You don't have any objection and you are not in disagreement that I have authority to issue the order that I'm about to order, correct?
Correct.
Based on the appeal that was filed?
That's correct.
Okay, so I'll ask Mr. Kuntz if you could send me a copy just so I can reference the appeal in the order. If you could just send me the final document sometime today, that would be great. All right, hearing nothing further. in case 230200001, I'm going to enter a limited record based on what the parties have agreed that I needed to look at this morning, which include the notice documents for today's hearing, which include USPS tracking, as well as verification of posting of a notice of hearing and the prior order finding irreparable and irreversible violation dated February 6, 2023. So I'll enter that composite exhibit 1 without objection. I'll find, based on the service documents in that case file and the agreement of all those present here today, that the town had good service for today's hearing. I will issue a mutually agreed order that assesses a one-time fine in the amount of $5,000 for the violation of sections 30-43, 30-44, 30-45, 30-49A, and also, just because the prior order referenced it, ordinance 2012-03, sections 2 and 8. I'll have all that reflected in the current order to match the previous order. I'll also specify in the order assessing fine that the parties are in agreement that the property has come into compliance as of September 5th, 2025, with the actual compliance date having been earlier, but the parties are in agreement with the 9/5 date. And I will, because I am assessing fine and because administrative costs were reserved in the prior order, I'll assess the administrative cost for that February 2023 hearing in the amount of $234.05. And I'll issue an order later today with that ruling.
That'd be
Okay,
great.
thank you.
Very much. All right. Thanks, Jen.
Do you all want to keep this back in
Yes.
your file, just so these papers, since they're separate, don't get lost after this? Thank you. Thank you all.
I was just looking on others. Don't help me, I can get up myself. Okay.
All right, go ahead. Thank
Next
you.
item is J&J Realty Investment Holdings LLC, 1555 Folsom Road, CE 25-15, PCN number 41 41 43 1701 637 0010, violations sections 22-132, 22-134, 22-135, and this is in reference to a business tax receipt. And I'll turn it over to Deanna Thomas.
Good morning, Your Magistrate. Deanna Thomas, Code Compliance Officer, Town of Loxahatchee Groves, presenting case 25-15 in reference to the property located at 1555 Folsom Road. Property was initially cited on 8/12/25. The NOV/NOH mailed regular and certified mail on 8/12/25. Green card was returned signed back to us, and it is in the file for your records to see. Affidavit of service is also in the file. The NOV/NOH was also posted at Town Hall 155 F Road on 8/12/2025. On being that the business tax receipts are coming due, I did go out to the property on 7/30, July 30th of 2025. I knocked on the door, nobody answered. I observed a woman working in the nursery. I asked if she was the owner. She informed me her name was Sarah and she rents from the owner. The property owner owes $450 for their BTR. They owe for the years of 2023, 2024, and 2025. This fee also includes the business tax receipt penalty of 25% for the years of 2023, 2024, and 2025. The town is requesting that this be paid within 2 weeks of today's hearing date.
Is the respondent present for this case?
No, ma'am.
So what evidence is there in the file that they're operating in 2023 and 2024?
There is a printout. If you look on the left side of the folder, it'll say Palm Beach Aquatics Inc. doing business as PBA Nursery Plant Products Wholesale 155 Folsom Road. And that shows a printout of the outstanding business tax receipts that they are operating. Plus, I did go to the property and I spoke with the tenant, Sarah. And she says that she is renting from J&J, the property owner.
So what is this spreadsheet from? Is this a town system?
Yeah, this is the town system showing that we track the BTRs when they get paid and when they're not paid. So this shows the delinquency.
No, I
for-
get that, but how do you know that they were operating on the site in 2023? What verification do you have that they were operating on that site? I understand that they didn't pay it, but I need proof that they were there in 2023 and 2024.
Let's see here.
The 2024 violation, I guess, is clear if you were there, because the business tax for this year are not quite due, right? They're due at the end of this month.
Correct.
So 2024, if you were there and you spoke with a tenant, I'm fine finding a violation for 2024, but I need a little bit more on the 2023.
I can't speak on that because I was not here actually during that time. Because I did not actually start working for the town until May of this year.
Let me go see if I can get, let me see if I can get from the state and get
Okay.
and see if they're operating. I'll be right.
Okay.
So if you want to pass it and then we can come back.
That's
and
fine.
I'll
If you want to
get
move
back
to the
you
next
since
case.
There's an individual here, so read into the record so that you can.
Okay.
All right, so on case 25-15, the town has requested a brief recess. We'll move to the next case and come back to that case in a few minutes. Mr. Suarez, I need to swear you in. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Go ahead.
The town's next case would be case number 2502014314885 North Road. Good morning, Your Honor.
Is that one? I'm sorry. On the agenda?
It's num-
Okay, thank you.
Morning, Your Honor. For the record, Code Compliance Officer John Suarez presenting case, and I'm sorry, Your Honor, it's CE 256 in reference to the property located at 14885 North Road.
That's where you got me. It was the case number I wasn't seeing. Thank you.
Sorry. This property was initially cited on July 29th, 2025. The property was posted with a notice of violation, notice of hearing on July 29th, 2025. A copy of the same was posted here at Town Hall. A signed green card via United States Postal Service is in the case folder as well. The property was cited for the following violations. Section 92010, RVs without a permit or registration or affidavit. The property use at this property is single family according to the Palm Beach property appraiser. The property is also on 5 acres of land. There are multiple RVs on the property. A check at Town Hall does not show a registration permit or affidavit on file. I have made contact with the property owner last week, Your Honor. She is here. A reinspection was conducted on September 4th, 2025, and it was found that the property remains in violations. There are still multiple RVs, more than two, because the limitation on 5 acres with an affidavit would be 2.
They would be allowed to have 2 with the
They would be
affidavit.
allowed to have
Okay.
2 with an affidavit.
There's no affidavit on file.
No affidavit on file, Your
Okay.
Honor. At this time, the town of Loxahatchee Groves is requesting that the property owner be granted 14 days to bring the property into compliance. Failure to comply with this period will result in a fine of $150 per day until compliance is achieved. Additionally, it is recommended that the administration costs incurred in the amount of $234.05 be assessed in order to be paid to the town of Loxahatchee Groves. I have the full case folder, and I'd like to submit it for evidence, Your Honor.
Ma'am, go ahead and go to the podium. Yeah, you're going to see the case file actually before I do, so you can go to the podium. What's your name, ma'am?
Patricia Hastings. Can I approach?
Hold on 1 second for me. What's your relation to the LLC?
I hear from Laura Zung, who is the owner of Dancing Crane Farms.
Okay, perfect.
And I also wanted to give you the initial evictions.
Okay,
Very well.
so let me have Mr. Suarez come up and look at these before I look at them. And then let me take a look at service. Don't go anywhere, Mr. Suarez. You can show her this case file too. All right, let me just look at, actually, go ahead and show this to the respondent's representative. Do you want that on there? Or you want to hold that? That's the evidentiary case file the town is asking me to admit. So take a look through those documents. Take as much time as you need. There's a bunch of papers in there. So review with as much time as you need, and let me know if you have any objection.
On this side where I posted on the property?
Right.
These are all-
That's what I have. Is it possible for me to get copies of these to send up to the owner?
Yes.
A lot of pictures of trees. Okay, I'm good.
Any objection to those documents being entered, ma'am?
No,
Okay. And can the town keep these copies that you've handed me, or do you need this?
no.
Do you
I
need
have
them back?
Major copy.
Okay, great. So what I'll do with that is I will admit the town's evidentiary case file as composite exhibit.
Actually, there's gonna be a change on the one because I thought he would be here and we'll be able to present it to him.
That's fine. I'll enter what you give me. If you send a subsequent letter, that's
I'm
fine.
going by, this is not happening. This he's not here.
Okay, that's fine.
So mail and posting will be done from this meeting and all, goes straight out to the property.
All right, so with that, I've entered the town's case file as composite exhibit 1 without objection. I'll enter respondents 2 pages, one of which is an authorization letter to authorize Ms. Hastings to be here at today's hearing, and the other which is a notice to tenant pursuant to chapter 83.56 Florida statutes dated September 8th. I'll mark those as exhibit R1, and I'll include those in the case file without objection by the town. All right, let me just look at all the documents. Mr. Suarez, you took all these photos?
Yes, ma'am.
How many RVs did you see on the property?
September, when we last went there, September 4th, I believe, we saw a total of 6.
How about on July 29th when you first initiated?
There were there were more than 6, Your Honor. I can't recall the number.
More than 6. Okay. All right,
E-
and the town's code requires for any of them to be there, there has to be the required paperwork.
Yes,
That's correct.
yes, Your Honor.
Okay.
Even one would require an affidavit on file.
Okay. And as of today, there's no affidavit on file?
No,
No, not even anything applied for?
no.
All right. Mm, all right, so Ms. Hastings, it looks like the property owner is giving these people 7 days to get the RVs out. Is that,
I was trying to give him 14 days, and for himself to leave at the same time. We've had issues with him in the past. He actually came into this office on Thursday, a couple hours before I did. And the code enforcement officers, when I said what I was here for, were kind of shocked. They thought the owner of Dancing Crane had already been in the morning.
okay, and
Yeah.
the gentleman that came in is the tenant?
Yeah.
Okay,
He's done this before, several years ago. He had Mr. Crane on his gate. He was taking trees off the property, telling people he owned all the properties that Dancing Crane owns. It's not the first time he's done this. He is a difficult man to deal with. I'm sure we're gonna have problems getting him off, but it's our full intention to get him off as quickly as possible, employ an attorney. From this point forward to continue the eviction. I'm just doing the initial first eviction paper. Likes of generosity from the town. Dancing Crane has been in the town for many, many years. I believe way before the town was even the town. I had nurseries out here when Okeechobee Road was a dirt road. So we go way back and asking for some sympathy from the town to give us the help to be able to get him off, because it's not, as hard as we work to get him off, it's not gonna be easy. I see the green cards there. The owners told me they signed them, but I wasn't aware of it. My husband picks up the rent checks and deposit them, and that's basically all that we do. However, we've had interaction with this man over the years when he couldn't pay his rent or he had problems here, and we did see problems there maybe 5 or 6 years ago, and he cleaned it up. So we allowed him to stay. But we had no idea it was what was going on the property to this extent. It's not like it's the property that we drive past every day and the rent check comes in the mail. So, I'm here because I became aware of it, and the owners are in Illinois. And, I am their agent, so to speak, for any of their real estate they do here.
Okay. So the town is asking me to give you, to give, essentially it's gonna amount to the property owners. I understand there's a tenant there, but the compliance date applies to the property owner, and the respondent's name is gonna be the property owners, for the property. So they're asking me to give you 14 days. That seems like enough time to get RVs removed.
Well.
You're
I-
giving him 7 days in your letter.
I have 7, I thought I put 14. So,
Removal of any and all quote enforcement storage within 7 days. 14 days should be enough time for him to
Yeah,
get the
yeah.
RVs removed,
I put
right?
7 because it was excluding Saturday, Sunday with holidays. You're right, if it was 5 or 6, but when they go back out there to inspect. For the Google aerial picture that I took, I think there's a lot more than 5 or 6.
Okay.
My concern is they're gonna go back out to the specs, and yeah, 5 or 6 might be gone, but there might be another 30 there. And if there's only 5 or 6 there, then yeah, the 7 days should be enough for him to get rid of that, and if he does, he might not even get evicted. But I don't believe that that's the case with Google photo.
I see there's an aerial. It's hard to tell from the aerial what all of them are. Does the town have a,
Get me more time.
what's the town's response to what Ms. Hastings is saying?
Well, the RVs that we have seen is what we could legally see from the public right of way. Now, that's not to say if we remove some or other type of storage, we can see a plethora of others. So how much?
Have because I really need more time. I suspect what's gonna happen is. It'll take a little bit of time to get him off because of that's why I'm gonna involve an attorney for that. But then the owners are gonna have to be the ones hauling off all this, and I'm getting ready to show it.
Show it to Mr. Suarez before you
Yeah.
approach,
That's as of last week. The trailer that he rents is, let me see what I can find it. That's another shot. That's where the trailer is that he rents. So I'm not sure where your view is taken. So this would be north over here.
I practically see everything on the outskirts here. Here, I can't see anything.
And over here. So, I mean, if you just blow this up and start counting, you can see where I have a problem. I do not believe the man is gonna get rid of this. I think he's gonna walk if he doesn't have a choice, which could take up to 30 days. But then we need to get rid of all that. And the owners want it gone. They want it and him gone. I showed them that picture. But again, he mails his rent check. We take care of the check. Had no idea.
are they all RVs or are they tractor trailer
No,
boxes?
they're boxes, they're boats, they're a little bit of everything you could find. I have a bad screen. She can't see it from here when you're looking at it.
How long do you need for full legal eviction?
Oh my God, I don't know. He's gonna fight it. He's not gonna leave. I have to talk to the attorney, which comes after my meeting today.
What, is the town amenable to giving her 30 days and then set it for a status/fine assessment? I'm not inclined to give, I understand you have to go through eviction. Yeah, that's even worse than in here. Okay. So go back to,
understand?
yeah, I understand.
Time to just falling out of there. And the expense isn't gonna be an issue for them. They're gonna pay it and get rid of it. But it's gonna take a little bit of time to get somebody to haul it, cause I don't know who will haul it, probably it's just towing or somebody.
Well, let me hear from the town.
The town is not opposed to giving 30 days, Your Honor. We understand it's a lot, especially during eviction. We don't
Yeah,
want
and what I'll if the town, I appreciate the town's willingness to give the additional couple of weeks. So I'm going to give you, I'm inclined to give you the 30 days, and I'm going to do what we typically call in the short lingo is a status/fine assessment hearing at the next hearing. So what that's going to mean is you're going to come back to me at that next hearing after the 30 days, and you're going to explain to me what you've done. I just want to make sure that I'm clear with you. I'm not inclined to, the eviction process can be a process, right? You've probably gone through that before. So going through that court proceeding and getting that ultimately done may take longer, depending on what's going on with the courts. That's separate and apart from the code enforcement violation. So I'm going to give you the extra time today, the 30 days, and set you for status/fine. But what I need you to come back to me, if you're going to come back to me in October asking for more time, I need to show that you filed your eviction papers today or tomorrow with the court, not just sending the notices, but that you are doing diligently everything you can do to get through the process.
Contact the attorney today.
Right. Just bring me back a timeline when you come back to me and explain to me that you've been diligent on your end, because
I understand.
yeah, sometimes these things, there's separate processes, and I can't always give you the full amount that you need, but you can always come back to me once there's ultimately compliance and get a fine reduction if I do ultimately impose a fine at the next hearing. But from your chair, the best thing to do is come back, start the process as quickly as you can based on what you're required to do under state law. But come back to me at the next hearing and show me that you have been working as fast as you can to get this resolved. Don't come back to me at the next hearing and show me a paperwork that you filed the day before that next hearing, right? I don't expect you would do that, but that's what I'll be looking for at that next hearing. So I'll give you the 30 days here today to try to give you the time to get moving.
Okay.
And then
Appreciate it.
come back to me at that next hearing with everything that you've done between today and that next hearing.
We have a date for the next hearing?
Yeah, I'm gonna specify that here in my
And-
ruling.
Your Honor, can we also ask that, get permission to come onto the property so we can take a look at it? Because when you have those kind of things, I want to make sure there's no oil seeping into the ground or anything along those lines. So as long as we have permission.
If you find that, I'd like to know.
Yeah, we can't go on your property without you granting us permission, so I'm asking it from you today.
And he will tell you you don't.
Okay.
Well, and I would, because I can't authorize the town to go onto the site, what I would encourage you to do is get with her and have her give you something in writing
Okay,
to authorize that permission. I can't order that or mandate that.
Okay.
So,
It might help our process if he knows the town can just walk on the property.
Mhm.
Point in time.
Okay. I also have his contact information. We could try to get together.
I don't know if he has dogs or anything. I don't know what he's got on him.
we would go on, and then if it's a harmful situation, we would back out.
Don't do this.
So we just go, no.
This is bad.
Mhm.
Very good old bad. Don't go on another shore. Watch out.
all right. All right, anything further from you, Miss Hastings?
No, I appreciate the 30 days very much.
All right, anything further from the town?
No, Your Honor. Well, the next hearing is on October 6th, which falls, I believe, within that 30-day time frame.
Are we not doing the Wednesdays? Are those going to switch?
They haven't implemented that red speed thing yet, so we're trying not to because I just don't know when it's going to kick in. So we're kind of staying to the Mondays right now. So I don't know if you want to make it like 27 days or whatever it is. So I think that's what you're saying is we don't want to make it 30 and it's not within the time frame.
Because you're not having the hearing on the 15th.
Correct.
A little more wouldn't hurt.
Honestly, I think we're generous enough by giving the 30 days. I'll be honest with you.
Say the thing.
No, that's okay. They saw it, but thank you. No, look, I understand.
What's here?
I understand, but also when I hear somebody on the record say, all I'm doing is accepting a rent check and I haven't gone out and checked my own property, we could have, well,
You know, we
I'm-
don't get paid anything. They're friends.
I
And there's
understand.
no reason.
but somebody could have checked before we got to here today. So,
Me and my ex-father-in-law, or my daughter's ex-father-in-law lives there, not there, but on one of the close by properties. But, you know, when you drive by and you look in the gate, I had no reason to pay attention to see what was actually there.
All right, so given the town's hearing schedule, I'm gonna set the compliance date of 10/5. That gives you just a couple of days shy of the 30, but as I said before, I'm gonna give you a status/fine assessment. So you're gonna come back to me on the 6th is the hearing date, October 6th. Um,
9 o'clock.
yeah, same time as today.
Correct.
Anything further from the town?
Nothing further.
All right, in case CE 25-6, I've entered both sides evidentiary case files and exhibits. I'll find based on the notice documents in the case file, which include an affidavit of posting and a signed certified mail that the town had good service for this morning's hearing. I'll find based on the photographs in the case file and the testimony of the code enforcement officers, as well as the respondent's representative, that the respondent's in violation of section 92-010, and I'll require a respondent to comply with that section on or before October 5th, or $150 a day fine will be assessed for each day that the violation continues thereafter. I'm going to set this matter for status/fine assessment hearing on October 6th. And then I presume, is there a cost recovery sheet in here?
For administration costs, Your Honor? Yeah.
Yes, you're asking for your administrative costs. So the other thing, having found the property in violation, the town's entitled to its administrative costs for today's hearing,
34.
$234.05, and those are payable within 30 days. So I'll assess those. And as I said before, come back to me on that October 6th date with everything that you've done from today going forward. I'm not telling you today that I won't start a fine running on that date, but I'm just saying I'll hear what's been happening and I'll make a determination at that
I
time.
appreciate it very
Okay,
much.
thank you.
Thank you.
My phone number, if you need it.
I do.
Okay.
We'll call you.
Thank you.
Be in touch. Thank you.
Are we ready to go back to number 5?
Yes, ma'am.
Okay, very good. So with that, just so the record's clear, I'll reopen 25-15.
So in order to show that they were operating, I'd like to present to you their 2022 Florida Profit Corporation Annual Report, their 2023 Florida Profit Corporation Annual Report, and 2024 Florida Profit Corporation Annual Report, and also 2025. So it shows all the years, if I may bring these up to you.
Yes, ma'am, please.
And the document shows that their principal operations, business operation is 1555 Folsom.
And that's the same business that's there now?
Yes,
That's
ma'am.
what it's called now, yeah, okay. Okay. All right, so I presume you want these added to the evidentiary case file?
Yes,
Yes,
please.
All right, I'll add those to the case file. All right, so what is the remedy that you're seeking again today?
The town is requesting that these fees be paid within 2 weeks of today's hearing date.
And what fees?
The $450, including their penalties.
Do you have the penalty amount?
Yes.
Is that in, maybe that's in here?
Yeah, it's in the chart.
Yeah, it's in the chart on the left-hand side of the folder.
It's a maximum of 25%, which is authorized by state statute and by our own code.
Okay. So it's in the spreadsheet, is that right?
Yes, and there's also code section 22-134, which is on the right-hand side of the file folder, that states when taxes are due, and the penalty for each month of delinquency. And that the total delinquency penalty shall not exceed 25%.
Okay, so your 450 total that's all in?
That's
a-
all in.
Correct.
Okay,
Mhm.
so I think for the record, breakdown, so for 2023, I would typically I always break these down in the order so that it's clear what the
Okay.
Okay.
what the business tax was, what the penalty is, et cetera. And so it's
Okay.
clear what years, because you're still only seeking 23 and 24, correct?
Yes. No, 25 as well.
Well, that's not quite due, right?
Well, the tax,
Just right. Not due
yeah.
October
Oh,
1st.
yeah, September 30th.
Mhm.
Yeah.
All right, so for 2023, it looks like from the table, the BTR is 100
Yes.
plus $25 for the 25% penalty.
Yes.
And then for 24, it's also $100, the license plus 25% or $25. So 250. That's correct?
Yes.
Do we have 22?
No.
No, okay.
All right, and this is clear based on the years we're talking about, but just for the record, the town's testimony is that the 23 and 24 business tax receipt delinquencies are more than 150 days delinquent. Is that correct?
Yes, ma'am.
Okay. And in the future, these are exactly the type of papers. If you can do it either way. If you have photographs, if you actually saw it back then, but that's harder.
Right.
But go ahead and include
Okay.
something similar to this or this in the future. That just helps me verify. All right, anything further from the town?
No, ma'am.
And I would also going forward, if you have multiple years, feel free to reflect the years that you're seeking in the notice of violation.
Okay.
Just because there's an argument that it should be totally clear how far you're going back, especially if we're going back several years. But that's, you've met the burden that you're required to meet today based on the documents that you have here, so. All right, with that, in case 25-15, for the record, the respondent is not present at today's hearing. I'll enter the town's evidentiary case files composite exhibit 1 without objection. I'll find based on the notice documents in the case file, which include an affidavit of posting and a signed certified mail, that the town had good service for today's hearing. I'll find based on the testimony of the code enforcement officers, as well as the documents in the case file, that the respondent's in violation of sections 22-132, 22-134, and 22-135 for failing to obtain the required business tax receipts for the years 2023 and 2024. And I'll find, and the order will reflect that for both of those years, the delinquency is greater than 150 days. So I will assess and require the respondents to pay both the license amount, which for both years is $100 for 2023 and $100 for 2024. For 2023, I'll also assess the 25% penalty authorized under state law and under the town's code, as well as the 25% penalty for the year 2024, which was not paid until, or has not been paid and is again more than $150 days delinquent. So that total amount will be $250, including the license amounts and statutory penalties. And that's it, right? Okay. So I'll issue an order that reflects that.
Did you ask for admin fees?
Sorry?
Did you ask for admin fees?
I don't
No.
see those in
Nope,
here. I
okay.
don't think you can get. They're
Not on
It's
that,
not
okay.
exactly the same for those,
Gotcha.
so that's probably why you didn't ask for those.
Okay.
Thank you. All right, do we have one left? Number one?
We get two left.
Two left?
Yep.
Two left.
Which one you want to do first?
Number one, number four, okay.
Number one?
Where are you headed first?
What do I want to do?
Whatever's first on the list after
Okay.
16 and.
All right, so the next one is Palenzuela, Gisela, and Leonardo, 2793C Road, 25040066, PCN number 41 41 43 17 01, 238 0020, violations sections 175-110, 175-170, 175-240, in reference to also FDA requirements, and then 20-017, prohibited use. Turn it over to John Suarez.
John Suarez, Code Enforcement Officer for the Town of Loxahatchee Groves, presenting case. Make sure I have this one right. 25040066 for the property located at 2793C Road. The property was posted with a notice of violation, notice of hearing July 11th, 2025. A copy of the same was mailed out certified to the property owner on file from Palm Beach Property Appraiser. And also a copy of the notice of violation, notice of hearing was posted here at Town Hall. Same date, July 11th, 2025. A signed green card is in the case folder. And there are photos of the posting in the case folder as well. This case was first heard on June 2nd, 2025, where the magistrate ruled in favor of the town and the property owner was ordered to correct the violations that were found. So the violations 20-017, prohibited use. Deadline was to be complied by July 7th, 2025. They are complied. Regarding the FDA, the application requirement, they were supposed to apply for the FDA permit by July 7th, 2025. That is complied. The third was to obtain and be issued an FDA permit by August 29th, 2025. They are not in compliance. I have the copy of the FDA site development permit in the case folder. It was signed by the town engineer and the town public works director. The property owner has yet to sign the permit. The permit cannot be issued without the property owner's signature. The town asserts that the property owner has failed to comply with the final condition required by the magistrate's order, namely the full execution and issuance of the FDA permit. The town is respectfully requesting that a daily fine of $250 be imposed beginning August 30th, 2025, and continue to accrue until compliance is achieved. Additionally, the town requests that administrative costs in the amount of $234.05 be assessed for today's hearing. Now I'd like to submit the case folder as evidence.
Thank you. You want that in the case file?
Yes.
Okay.
And for the record, Your Honor, the town permit tech has emailed the property owner as well as his engineer requesting that the permit be signed. She has not received the reply as of yet, as of today.
Were they present?
His engineer was
Yeah,
present,
there was a representative, yeah, okay.
Mr. Patrick, I believe.
That's unfortunate. They got so close and. So we haven't heard back, you haven't heard back from.
We have not heard back
Nope.
as of yet. I even emailed him.
And the town signed off on this stuff on August 26th on the permit.
Yes.
Okay. And did they pay is there a fee for this permit?
They paid the fee to get this far, yes, Your Honor.
So all they didn't do was sign.
To be fully executed, yes.
Okay. All right, and you said that the prohibited use violation has been cured,
Yes,
and it was cured by the time specified in the prior
by
order?
July 7th, I believe I said.
Okay. All right, so this, and they applied by the time specified in the prior order, so this is just for 175, 170, 175, 110, and 175, 240. Okay. All right, anything further from the town?
Nothing further, Your Honor.
You don't know how many, can you count the number of days for me that is from
From August
August
30th?
29th? Yeah, started on August 30th to today. How many days is that?
My phone is off.
Okay, now here I got it. Hold on.
9 days from today.
Thank you. 9 days? August 30th.
10 days.
I'm sure there's.
10 days including today. So 10 days times 250. Don't trust the lawyer's math, trust the calculator. 2,500. All right, and do you have a cost recovery sheet for today's hearing? Or are you asking for
I-
cost recovery for
I'm
today's hearing?
requesting the administrative cost be assessed today's hearing
And
in the
what's
amount
that?
of $234.05.
And have the admin costs from the June 2nd hearing been paid?
No.
No,
All
no,
right,
Your
so
Honor.
I'll reaffirm those. June 2nd. Okay. All right, anything further from the town?
Nothing further, Your Honor.
All right, in case 25040066, I will admit the town's, first for the record, I'll note that the respondent is not present. I'll admit the town's evidentiary case files composite exhibit 1 without objection. I'll find based on the notice documents in the case file, which include an affidavit of posting, as well as a signed certified mail that the town had good service for today's hearing. I'll find based on the testimony in the case file, as well as the documents in the case file, as well as the testimony of the code enforcement officer, that the respondent was required to have, pursuant to my prior order dated June 2nd, to have had their FDA permit issued to comply out sections 175, 170, 175, 110, and 175, 240. Having reviewed the FDA permit in the case file that was signed off by both the town engineer and the town public works director on August 26, 2025, but that remains unsigned by the property owner, that the respondent did not comply with that date, as the FDA permit has not been fully issued by the required compliance date of August 29th. So I will issue an order assessing fine that assesses a fine in the amount of $2,500 for the violation of sections 175, 170, 175, 110, and 175, 240 that persisted on the property from August 30th through today, September 8th. That's a total of 10 days, and that fine will continue to accrue at $250 per day until compliance is achieved. I'll reaffirm the administrative costs that I imposed at the June 2nd hearing in the amount of $234.05. And I'll assess the town's administrative costs for today's hearing in the amount of $234.05 payable within 30 days.
Ready for next case?
Yes, ma'am. Thank you.
Next case is Aramis Lopez, Javier Vega, Leonardo Vega, and Juan Lopez, 1316 B Road, CE 25-16, PCN 4141431701 205 1101, violations section 30-44, 30-43, manure violations. Turn it over to John Suarez.
For the record, John Suarez, Co-Compliance Officer for the Town of Loxahatchee Groves, presenting case CE 2516 in reference to the property located at 1316 B Road. The property was initially cited on August 12, 2025. The property was posted with a notice of violation, notice of hearing on August 12, 2025. A copy of the same notice was mailed certified mail on August 12, 2025. And also a copy was posted here at Town Hall. I have not received the green card as of yet. The property was cited for the following violation: section 304-44, permit needed for manure. Section 3043, prohibited for the property owner to permit the depositing of manure and horse bedding, as he has a tenant on the property. The property use code via the property appraiser is 6900. It's an agricultural classification of ORN and miscellaneous agriculture. The property is also on 10 acres of land. The property was operating a manure transfer station. There are photos of trucks depositing and grading the manure. In the case file, there are photos from as early as November 22nd, 2024 of large piles of manure. I have spoken with the tenant in the meantime. He was telling me over time, he was telling me he was just keeping it for his own personal use. They would be spreading it for his nursery. But after talks with our public works superintendent, Craig Lower, it was just too much. It was not the case. And over time, I saw more and more manure, and it wasn't being spread on the nursery. So I inspected the property on August 25th. After speaking with the property owner, he told me he would meet me there. His name's Leonardo Vega. He showed me that the manure was removed from the property, and I also spoke to the tenant, and I informed them both, whether in compliance or not, I need a finding of fact because this has been going on too long. At this time, the town respectfully requests that the special magistrate issue a finding of fact that a violation did exist on the subject property. Furthermore, should the property be found in violation of sections 3043 or 3044 of the town code on or after September 8th, 2025, the town requests that a fine of $500 per day be imposed immediately upon the finding of violation and continue accruing daily until the violation is fully corrected. It is also recommended that administration costs incurred in the amount of $234.05 be assessed in order to be paid to the town of Loxahatchee Groves. I'll submit the case folder of evidence.
Thank you.
And for the record, Your Honor, anytime you have manure, you do need a permit with the town or an affidavit stating that it's for the property's own personal use.
Okay. So you were out there again on the 25th of August.
I was with the property owner.
Okay. Was there any manure left on the site?
I did not see any. And they did tell me they removed it and took me for a tour around the property to confirm not only the piles where they were placing it, but they took me on a golf ride throughout the property to show me there was no piles of manure.
Were you out there again after the 25th?
Not after the 25th.
So the trouble I have is your notice of violation gave them till September 2nd to comply. So technically they complied. I can't give you a finding of fact because they complied before the date you specified. So unless you were back out there again after September 2nd,
But the violation existed, Your Honor. I mean, there was no need to go back out there if they were in compliance. So I just wanted to take it for a finding of fact that the violation existed. And this has been going on, it's been an ongoing problem at this property.
no, I understand that. I think that that's very clear in the photos. It's just the way that the notice was written. I can't find him in violation based on your notice. So I agree with you that there was a violation, but you gave them a specified time to cure the violation and they cured it prior to that date. So the only way that I could find him in violation is if you recite it as an irreparable violation. Based on this notice, I can't give you a legally defensible finding of fact. Because for me to give you a finding of fact means that they complied, but they complied after the date you specified in the notice of violation. But that's not the facts here as I understand them. Is that accurate?
That was not my understanding, Your Honor. My understanding was that whether they came into compliance or not before the time frame, that the violation existed, and I could still take them for a finding of fact. Where are you stating it from? A Florida statute?
Because you specify in your notice of violation the time that they have to comply. So you have to by law give them a reasonable amount of time to comply. It's like if it were you and me and you told me I had to fix something by September 2nd and I fixed it before then, I'm complied out, just like you pulled those other cases off today's agenda. I presume that was the exact same scenario that they complied by your specified date. That's why it's less common with this type of case, but that's very common in parking violations, right? You give somebody 3 days to comply. It's kind of becomes a cat and mouse game. Technically, legally, I can't give you what you're asking today. I would not be opposed to if you renotice it, hearing it again. I think there's an argument that it's an irreparable violation, but based on the date you specified in your order, in your notice, I don't have any evidence that they didn't comply.
Okay, Your Honor. We might do it for irreversible. Write it up different next time.
Okay. All right, so your request for number 4 is to pull it for 2516.
Yes, Your Honor.
That appears to be everything.
Yes, the only other thing, Special Magistrate, just to let you know, the town attorney just handed me the order from the Seaforth property that you had, showing that they affirmed the action. I want to
Okay,
hand it to
perfect.
you.
If I can take a copy of that, that'd be great. Thank you. All right, and just for scheduling purposes, so obviously the 6th is happening. Should I keep the 15th on my calendar?
Is that September 15th? Do you have any case?
I'm sorry, I was thinking October. The 17th is,
17th?
17th is correct.
Right.
okay, that one, there were some things from last hearing. So October 6th, should I keep the October 15th on there?
I think, no, for right now. Well, the only reason unless there's any tickets, which I don't think there will be, so I just.
I'll leave it on there and then if you'll let me know as it
I
gets
will.
a little bit closer, maybe the end of the month.
You got it.
All right. Hearing nothing further, I'll adjourn this hearing at 10:16.
Thanks, Mitty.
Thank you.
We'll see you in a couple of weeks.
Yes, ma'am.